This is information that I would like to give you concerning the Adam Walsh Legislative Act of 2006. Specifically, it is the Adam Walsh Child Protection and Safety Act of 2006. The purpose of the act was to establish a comprehensive national system for the registration of sex offenders and offenders against children. Remember that we discussed the state requirements. Well, this broadens those requirements. The act broadens the definition of sex offense says to include, 1, a criminal offense that has an element involving a sexual act or contact that is a specified offense against a minor. Here you are bringing in, for example, voyeurism, where you are using webcams. That is now a federal offense. B, or 2, federal offenses involving sexual trafficking, sexual abuse, sexual exploitation, or abuse of a child, or domestic assault, which I thought was kind of interesting. That is a new amendment in terms of domestic assault. 3, a specified military offense. Again, they are broadening what is meant by a sexual offense and who is going to register. And D, it also broadens the specified offense against a minor to include kidnapping, false imprisonment, which occurs a lot when you are sexually procuring children. It also is defined as sexual solicitation, video voyeurism, which I think I like because that really attacks the cyber sexual exploitation, production or distribution of child pornography, and attempt or conspiracy. Conspiracy here means that if we talk about it and I actually buy a webcam, that we are going to begin to expose ourselves, or we are going to start to use webcams to have visual contact with children. The act of buying the webcam, connecting it, and searching some sites would be enough for conspiracy in many instances. So conspiracy to commit any of the above now is also part of the sex offenses that the federal government can get involved with in terms of prosecution. Another one, this one requires all 50 states, including the District of Columbia, all federal territories that are governed by the United States, and all Indian tribal reservations to maintain a registry of convicted sex offenders. So it not only broadened the number of sexual activities that are now clearly defined as illegal and punishable, but it also broadens the territory that the act would encompass. In terms of sexual registry, the act requires sexual offenders to do a number of things regarding registration. First, when you are convicted of a sexual offense, you must register in each jurisdiction where you are going to reside. So if you are living in one state and also working in another state, then you have to register in both, because it requires you to register where you are going to be employed. And if you are enrolled as a student, you have to indicate that information at the registration process, the name of the school and where that school is located. 2, the offender must keep such registration current. and we'll talk about how this changes the law in that regard. But generally, you are to present yourself annually to the jurisdiction where the registration occurs. I would say pragmatically that is probably the local sheriff's department, or will be the local sheriff's department, or if it is a federal jurisdiction, probably the U.S. Marshal's office. 3, the Act provides a minimum of at least 1 year in federal prison. Now, it can be more, it can be as much as 10 years, but if you fail to register, then it is upon conviction, it is going to be an additional, at a minimum, 1 year you are going to serve in prison for that failure to register. Another one, under this law, the minimum requirements relevant to the information required by the sex offender has changed. And here we are talking about specific information such as places of employment, as mentioned before. A new one that I have not seen is, at a minimum, the federal government are requiring states and local authorities, or jurisdictions they call them, to also ask for license plates numbers of all vehicles owned. They are also asking for physical descriptions. I think we've talked about that before. They want a current photograph, which here would be every year. They are going to also encapsulate a criminal history in the registration process. And they are asking for 3 pieces of very specific physical identification features. The first is fingerprints. The second one is a palm print. And the third one is a DNA sample. And a number of years ago, I'm going to say, maybe in the early 90s, there was a federal law that was enacted where if you were in prison or in a jail being convicted of a sex offense, you also then had to give a sample of your DNA. Now it includes, when you are arrested and not convicted, you are also going to provide a sample of DNA. Now that will not be part of the registry, because if you have not been convicted, you do not have to register, but they are going to take that sample upon arrest. Requirements in terms of the length that one is responsible for this registration process, it generally will depend on the seriousness of the offense, but it will be, what I have read, at a minimum of 5 years upon conviction of a sex offense, and for the more serious, it can be for the rest of your life. The offender must appear periodically, as I said. Generally that is annually in person, to verify all of the above information and to make sure that nothing has changed. The Act requires the appropriate official of the jurisdiction to notify the sex offender of the duty to register prior to his or her release from custody. So if you are the warden of a prison, then prior to release you must indicate in writing that you have a legal responsibility to contact your jurisdiction, which would be the county sheriff or the place where you're going to reside, and begin the process. Also, if you are under any kind of supervision, such as probation, before you are going to be placed on probation, you have to register, or you have to be told that you must register immediately upon being sentenced for a sexual offense. The Act requires the jurisdictions to provide us, the public, access to sexual offender information. And here the Act adds a new dimension, and that is through the Internet. So every local jurisdiction must provide the information that we have just gone over to us made available through an internet site. Further, the Act also requires the U.S. Attorney General through the FBI to maintain a national offender registry. Prior to this, I do not believe that it has been legislatively required or compelled. Now it is. So there is not only going to be a local registration process, but there is now going to be a national registry or database of sexually convicted offenders, or offenders who have been convicted of sexual crimes that have to register. And further, the Act requires that the FBI must immediately inform all relevant jurisdictions if any of the changes regarding the individual offender and his registration information have changed. The FBI have more of a means of a national database through the National Crime Information Center and also through other computer programs, that when somebody is arrested, there is an immediate record that is kept upon booking and placed in the computer. So the FBI has a much more broadened or in-depth data bank of this kind of information. And now the FBI is required to notify the local jurisdictions if there is any change that they are made aware of the sexual offenders who are living in their jurisdictions. The Act requires the Attorney General to assist jurisdictions, and I think this is an important one, to develop and support software to enable jurisdictions to establish and operate uniform offender registration internet sites, which means that you are going to, no matter where you live as a citizen, if you are concerned about the sexual offenders residing in your neighborhood, you are going to be able to have a website that you will go to, and that website, no matter where, will basically have the same look, which means that you can learn how to navigate and will have the same information. I think that's an important one. In other words, it is going to offer us as the community standardization as we review or search for this kind of information. It also provides, that is the Act, it requires all jurisdictions to participate in using the software, which again is important, and excuse me, and accumulating all of the required information. Now, when the federal government gives you a legislative mandate such as this then becomes the minimum standard. So if West Virginia wants to require more information, they can do that, but at a minimum, they must accumulate the information that we've just gone over as compelled by the Act. And I like this because it gives meaning to not participating in the software program that makes it standardized, because if you do not, then each state is going to have a reduction of 10% of the omnibus crime control monies that they get annually from the federal government. And we are talking here of hundreds of millions of dollars, and 10% is a significant sum. So if you do not participate as a state authority in this program, then you are going to be cut 10% of your funds until you decide that you are going to participate. And I don't think there is any reasons why states would not. Sometimes there is a matter of apathy. Sometimes there is a matter of just motivation or initiative. Well, losing 10% of your funding will probably provide all three of those. The amendment, excuse me, it amends the criminal code of the federal government to impose a fine and or prison term of up to 10 years for convicted sex offenders' failure to register or to update registration. It also modifies probation and supervised release for sex offenders. And here, I know we've talked about the increased penalties of up to 10 years, but it further mandates that you are not going to receive probation, at least in the federal jurisdictions, and you also will probably not be released early from a federal prison on a supervised release program if you are convicted of a sex offense. So ultimately, you are going to do more time, and your time is going to be within the walls as opposed to supervised release within the community. The act requires the U.S. Attorney to use federal law enforcement resources, including the U.S. Marshals, to assist jurisdictions in locating and apprehending sex offenders who fail to register. So you can see, or you should begin to get the feel that we as a nation are becoming very serious about the monitoring of sex offenders. In fact, what I am beginning to realize is that this is going to be an industry in the next couple of years. You are going to find more private companies and corporations getting involved in this monitoring process because of the millions, if not ultimately billions of dollars that are going to be spent by the federal government to assure that the Walsh requirements are implied and implied in all of the states. It directs the U.S. Attorney to create and maintain a, and I will quote, Project Safe Childhood program. And what this proposes is the Attorney General of the United States is responsible for the following under that program. One, to integrate federal, state, and local efforts to investigate and prosecute child exploitation cases, so it makes them a priority. Two, the Department of Justice will offer major case coordination. By that, if you have several states that are investigating a child pornography ring, well, the feds can come in and offer coordination through their resources, which are far more exhaustive than those in the states. Third, it will increase federal involvement in child pornography and enticement cases in the areas of enforcement training, because a lot of the child pornography is now on the internet and it is cybercrime. A lot of jurisdictions simply do not have the sophistication to monitor, to properly investigate, and to collect evidence to get a conviction when it comes to cybercrime. So the federal government is going to help to close that loophole by offering specific training that will be required by state authorities to attend and to learn how to investigate cybercrime in a meaningful and substantive manner. And the Act provides increased funding for community awareness and education programs. I know that by now you know more information just as a cursory examination of the topic than do 99% of the population who are not involved in the investigation or the enforcement end, or who are sex offenders themselves about the nature and also the laws regarding the registration process and the techniques of investigation, etc., concerning child sexual exploitation. So I believe personally this is one of the more significant requirements of the Act, and that is it places money in the U.S. Attorney General's office to then make grants available to local communities to do education awareness, much like this class is providing you. It also provides for funding, and I think this is an important one because these personnel are directed specifically at cybercrime. It provides funding for an increased, excuse me, for increased personnel. It will give 10 new attorneys to the Internet Crimes Against Children Task Force, which is a prosecutorial task force, and it also will provide up to 8 new employees to the FBI's unit on innocent images, and we'll talk about that in the next section. The emphasis, as I say, of these employees are on the area of cybercrime against children. This one is, now we get a little specific, but I want you to think about the meaning of this. The Act establishes in the Department of Justice an Office of Sex Offender Sentencing, Monitoring, Apprehending, and tracking sex offenders, to be headed by a presidential appointment. So we are going to create on the one hand, perhaps another level of bureaucracy, but it is also going to be one that is charged with monitoring, tracking, investigating, and apprehending the sex offender. The office will be authorized to do the following. 1, administer the standards for the sex offender registration and notification program. So they are actually going to go out and check websites of local jurisdictions to be sure that they are doing what we are talking about and what is compelled by the Act. 2, they will administer grant programs relating to sex offender registration and notification. So this is the office that's going to develop the software and is going to help train the state and local authorities in the proper utilization and application of that software. And 3, it will cooperate with and provide technical assistance to the jurisdictions and other public and private entities involved in sex offender registration and notification. So this is going to be an office that will coordinate all of the local and state efforts and hopefully culminate into some kind of a meaningful registration program both at the federal and ultimately local level. The Act provides access to the NCIC, and we talked about this in the video, the National Crime Information Center database, to those who work with children. And I think this is an important one. For example, if you are a principal, you are going to have access to this. If you are getting ready to hire a teacher or even a janitor. If you are in a foster care agency, it's going to be important for you to know who is applying to be a ward to those children. So you will have access to the database. It also, child protection agencies. All states will have some agency that is responsible for child care and child welfare. they also will have access to this database to be able to monitor potential employees. Volunteer groups such as Boy Scouts or Girl Scouts now will also have access to this database, especially concerning the nature of the organization where much of this is volunteer, and therefore you do not have a lengthy application to fill out. Enhancements, as you read the legislation, enhancements of all penalties relevant to sexual deviation, child pornography, and failure to register have been included in the Act for these offenses. There is a significant increase in penalties going into 2007 prior to that date. Also, the Act requires mandatory prison sentences for those convicted of violent crimes against children, such as sex crimes against children, and also those crimes resulting in death, the distribution of materials involving the sexual exploitation of children, or child pornography. Using, I think this one is interesting, using misleading internet domain names to divert children to harmful materials, such as a Mickey Mouse name, and they go there and there is a picture of people fornicating or children involved in various positions of nudity. That now are crimes that will be seriously examined, prosecuted, and if convicted, will fall under this act in terms of significant punishment. It also adds sexual abuse of wards, and here wards, and I'm saying W-A-R-D-S, are, for example, foster care, those who are guardians. You are now going to be involved as a sex offender if you violate those above crimes as part of the guardianship. And failure to report child abuse, which I'm surprised to read that, but it is there. I know that if you are a teacher, you are responsible in all states that I'm aware of, that if you suspect child abuse, to report it. Well, now it is going to be part of the sex offense crimes that if you do not report, then you can be culpable and ultimately indicted and convicted for failure to not report. The Act directs the U.S. Judicial Conference to study the necessity and desirability of amending the federal rules of evidence to provide that the marital communication and adverse spouse privilege be made inapplicable in any federal criminal proceeding against a spouse who is charged with a crime against a child. Now, all that is meaning that you know, or you have heard probably, that when you are married, there is a guaranteed immunity that your wife or husband may not be compelled to testify against you, even if they know and are have direct evidence of a crime. So if the husband is sexually abusing a child, then he may get the wife to not testify based on this immunity. And if that is the only evidence that is available other than strong suspicion, then that person may not be held responsible for the crime. That may be, and I say may be because it still is the law, of spousal immunity, but that may be found inapplicable, and no longer will you be able to claim the spousal immunity charge in terms of testifying against your husband or wife. That one will be interesting. The act will extend certain rights to victims in federal habeas corpus proceedings, and habeas corpus means that where you may have been, you are an offender and you are in prison, and you write the judge and say you are wrongly accused and something is occurring in prison that you need to be before the court to talk about. And as part of it, they may bring you in as the victim again after you have gone through trial. Well, this act will give you certain rights as a victim, including the right not to be excluded from public court proceedings, which in some instances, some of these habeas corpuses are not made public. Well, now as a victim, you are going to be able to demand the right to be present during all hearings. 2, the right to be reasonably heard, which means that you do not have to remain silent, and that is you can say, I would like to address the court at the appropriate time, and according to this act, you should be given the privilege to do so. 3, the right to proceedings that are free from unreasonable delay. Now, this one I find to be interesting because a lot of this really is dominated by the defense and the prosecutorial attorneys. But nevertheless, it is here. As a victim, you have the right to proceedings free from unreasonable delay. And last, the right to be treated with fairness and respect. Now, with that, I have completed what I believe to be the major additions and amendments to the child protection laws at the federal level, and Walsh brings us to 2006. So we will continue the section, and I am going to take a look now with you at the FBI Innocent Image Unit.